Hello friends, in the series on the income tax cases, today we will discuss another case which is on the issue of section 148 notice on not valid grounds to issue the notice, and that is why the Bombay High Court quashed the notice under section 148 for inappropriate reasons for no relevance of reasons with the income escaping assessment. The moot question before the Bombay High Court in the present writ petition was that if the notice is issued to the assessee under section 148 for the allegation of income escaping assessment on the ground that some expenses have been incurred by the assessee which is not for the purpose of the business of the assessee, and those expenses have also benefited some other assessee. This was the only reason for the issue of the notice under section 148 without appreciating the whole case of the assessee. This matter has been taken up by Bombay High Court in a writ petition in the case of Sun 10 Trading Company Limited versus Deputy Commissioner of Income Tax and others, and this case has been reported in 465 ITR at page number 540. The date of the judgment is 2nd February 2024. In the present case, the assessee has an agreement with D group of companies for distribution, marketing and sale of imported alcoholic beverages in India. According to that agreement, the assessee has to take the appropriate advertisement, merchandising, promotion, packaging and consumer research with respect to the product sold in India. According to that agreement, the assessee incurred some expenses. The assessee filed the return of income, and after some time the assessee was issued a notice under section 148 on the basis that these promotional expenses has not been incurred for the purpose of the business of the assessee, and they have benefited the other company DIPL also. The assessee filed the objections, but those objections were not considered by the learned assessing officer. So the assessee filed the writ petition for challenging the notice issued under section 148. When this matter was heard by court, the court said that even if expenses have been incurred on the direction of DIPL, that is the other company, and even if they have benefited to the other company to some extent, even then this does not take the right of the assessee to claim the deduction under section 37 subsection 1. The court said that in the present facts and circumstances, when the revenue have itself admitted in the affidavit that the assessee is dealing in importing foreign liquor and selling them into India by doing some promotional expenses according to the agreement, and even in the reasons recorded, the revenue have admitted the same fact which were given by the revenue in the affidavit at the time of the writ petition, those facts were correlating with each other. So in the present facts and circumstances, it cannot be acceptable or it cannot be accepted that the expenditure were not incurred for the business of the assessee. The court said that in the present facts and circumstances, when the notice has been issued just for the reason that some expenses have been incurred for the benefit of some other persons, then in that case, whatever the reasons have been recorded by the revenue would never lead to a prudent person to form an opinion that the income of the assessee has escaped assessment. So, in the present case, the court held that the reasons are not relevant for issuing the notice, or the reasons are not relevant for making the belief that the income has escaped assessment. So, the notice under section 148 deserves to be quashed. At the end of this video, once again, I am repeating the name of the case. The name of the case is Sun 10 Trading Company Limited versus Deputy Commissioner of Income Tax and others, and this case has been reported in 465 ITR at page number 540. The date of the judgment is 2nd February 2024. Thank you, friends.